Welcome everybody, welcome to yet another job retention scheme webinar with our, as I like to call them, in-house experts, Kirsty Rogers from DWF Group and Simon Parsons from SD Worx. I've got Gina with me from the HTL team, and for those of you who don't know me, I'm Atria Kulayani, founder and chair of HTL. Today we will be talking about job retention scheme, but also what has been called now CJRS 2. I'm not going to use the acronym that some people have used on our WhatsApp group, starting with F, flexible furlough scheme, which was quite funny, but I wouldn't say that during the webinar today. And really talking about today, trying to understand the new rules, understanding the interaction between scheme 1 and scheme 2, thinking about communication to employees and the need for a new furlough agreement, the dreadful, I think, certainly from my perspective, calculation of usual hours and furloughed hours and all of that will leave all of the tough questions to Simon. Simon to try and help us make sense of that. And then the claim periods, adjustment to claims, talking about as well about record keeping and so on. A couple of things for your questions. Can you please use the chat function as opposed to using the Q&A? So there is only one thing that we need to keep an eye on. We'll try and answer all of your questions either live or just typing the answers as we go along. These sessions are always very interactive and very engaging. So this is your opportunity to ask any points of clarification from, our experts are here to help you and help you navigate the understanding of what came out very late on Friday night. So I will hand over to Kirsty, who will get us started, and over to you, Kirsty. Thank you very much for being here.
Thanks, Taya. Morning, everybody. So as promised, the guidance came out on the 12th, but at 10:30 at night. So although we waited for it all day, we didn't get it until very late, almost the 13th, but at least they gave us a date. And we are expecting the direction, because this was just the guidance, but they haven't told us when they're going to send that. I'm going to try and give you some controllables, key dates, information we do know. I'll link into some of the guidance on the calculations. I'm not a mathematician, so I won't go through that, but there are some specific areas we need to be aware of, and I think Simon's going to talk through some of those as well. Both of us prepared for this over the weekend, and it's fair to say there's a significant overlap in the slides that we produced. So at least that tells us we're on the right lines in terms of the things we should be telling you. So to repeat, Gina, if we have the first slide, the scheme's been extended to the end of October, and from July the 1st, next slide please, Gina, individuals will be able to partly work and partly be furloughed. The Chancellor's made it clear that the scheme will be closed to any new entrants from the 30th of June, meaning that the final date an employee can be furloughed for the first time is the 10th of June. So we've passed that date. So if people haven't been in it before, they can't now claim, except for those individuals who've been on family leave. They'd clearly forgotten about those. And on the 9th of June, we got an update and more guidance saying that anybody who had been on family leave and hadn't been furloughed could still be furloughed, provided their employer has furloughed other people. So it's important to remember that there has to have been some evidence of use of the furlough scheme by an employer for those people who've never been furloughed but have been on family leave to make use of it. And the 10th of June date is only relevant for brand new entrants. People could go on the furlough rotation, so the 21-day rotation after the 10th of June, and it can overlap the 30th of June in terms of the 21-day rotation, because the 21-day rotation will still apply. However, that does mean, because there is now a requirement that any claims are submitted on a month-by-month basis, that any claim that overlaps the 30th of June period will have to be into two parts, essentially. So that's very important that we are aware of the specific dates. Any claims that are up to the 30th of June have to be submitted by the 31st of July. If you don't put in your claims up to the 30th of June, by then you won't be able to pursue a claim. So that's really critical. And the additional point that's come in as well is anybody TUPE'd after the 10th of June is eligible to be put on furlough, even if they've never been furloughed by you, provided they've been furloughed by a previous employer. So they've covered those people as well. And Emma, I think, is asking, will we share our slides? Yes, we will. They do repeat one another, but we will be sharing our slides. So if you go on to the next slide. In terms of flexibility, employers will, from the 1st of July, be able to mix furlough and working, or people can continue on full furlough. I've heard some myths about, oh, you've got to have them back in work a bit. You don't. You can continue on full furlough, but additionally, you've got this opportunity to mix furlough with some working days and some furlough days, and that can change on a week-by-week basis. So it's really to enable as much flexibility as possible whilst we are in this return to work phase. And just to confirm then, there are no grant changes, no changes to grant levels in June or July. Government will continue to pay 80% of wages up to a cap of 2,500 for the hours the employee is on furlough, as well as employer NI contributions and pension contributions for the hours the employee is on furlough. Employers will have to pay employees for the work that they do. So if they're working, they're entitled to their usual normal rate of pay prior to furlough, unless you've agreed something different, which I suspect you won't have. And then there will be a furlough calculation based on those hours that they are on furlough. From August, the government will pay 80% of wages up to a cap of £2,500 for the hours an employee is on furlough, and employers will then pay employer NICs and pension contribution for the hours they're on furlough, which I think is about 5%. September, government pays 70% of wages up to a cap of £2,187.50 for the hours the employee is on furlough, and employers will pay NICs and pension contributions and top up the employee's wages to ensure that they get 80%. And that's on top of any work that they may be doing under flexible furlough. And that's before we get into sick pay or holiday pay. So you can see it's going to get quite complicated. And then finally, from October, the government will pay 60% of wages up to a cap of £1,875 for the hours the employee is on furlough. Employers again paying employer national insurance contributions and pension contributions and topping up wages to 80% up to a cap of £2,500 for the time they're furloughed, plus any payment for hours that are worked to be paid in full. So you can see it's going to be a potentially complicated calculation. So moving on to the next page. Before we get onto the calculation, we look onto the key information. The first date that you can claim is the 1st of July. There is no ability to claim in advance. So be ready from the 1st of July because you're simply not going to be able to submit the claims before then. and the minimum furlough claim period is going to be 7 days. So you've got to do it on a cycle of 7 days or more, but not less than that. And it's important that you have a written agreement with your employees in relation to this flexible furlough period. And it should be a different agreement to the furlough agreement you've got at the moment, because it is such a change. Unless you're going to continue with people on full furlough, our recommendation is that you have a new agreement, and that agreement should be kept for 5 years, and the employee has to be told when you're making a claim. So you need to be really clear that I am claiming for you, you're telling them, and you have written down what the agreement says in relation to the terms of any flexible furlough. There's been a bit of debate, and it's not clear in the guidance whether this needs specific consent. Most of the commentary I've seen, which is only over the weekend, says consent specifically doesn't need to be written. The employee doesn't need to write back and formally consent, but it does need to be in writing. And that's not guaranteed. We may see an update on that. As with all these seminars, things change on a daily and weekly basis. And interestingly, one of the other changes around the agreement that has been brought in is that it has to be compliant with employment law, which was already there, but they've also specified it also has to be compliant with equality and discrimination law. So there is clearly an expectation that there are going to be some Equality Act claims in relation to flexible furlough, but furlough generally, because that has become so specific in the guidance that came out on Friday night. So in terms of the actual calculation and what you submit to HMRC when you're claiming, for each claim period, you will need to include, as well as the usual information that you include, the number of usual hours an employee would have worked prior to furlough. And also within that, the number of hours the employee is going to work. How many, and it is by hours, not by days, how many hours are they going to work? And then additionally, the number of hours the employee is actually going to be furloughed during the claim period. The guidance is saying that payments subject to this information being submitted correctly will be made within 6 days, provided we have everything in there. And they are very specific that we must include all the applications on one claim, regardless of differing pay periods. So those on monthly and weekly cycles, all to be included on the same claim. They have indicated that for those organisations who claim for more than 100 people, they will be providing a spreadsheet which you'll be expected to complete in a specific way. So look out for that, because it seems to me that compliance with the guidance on how you claim and what you specifically put in will be very important to making sure you get a swift payment. So moving on again. If you're using flexible furlough, you need to work out usual hours, and guidance is provided on usual hours. And I have put a link that is a live link to that guidance. It is really complex. Done our best to summarize that. In brief, where pay doesn't vary, the calculation is based on the number of hours the employee was contracted to work at the end of the last pay period, ending on or before the 19th of March. On where it's variable pay, usual hours are generally calculated based on the higher of the average number of hours worked in the tax year 2019-2020 or the corresponding calendar period in the tax year 2019-2020. As I've said, the guidance is there. Put a cold towel on your head before you read it, because it isn't easy. And as you're reading it, I had to keep rereading it because the words were all just merging, because it is quite complicated. But that is sort of the brief rule of thumb in terms of the summary on that. And if you just go on to the next slide, you'll see Maths is important. Employers need to calculate 80% of usual wages to determine how much they can claim under the CJRS for furloughed hours. And it's not just 80% of a week's work, it's 80% of what's left. HMRC have provided a worked example. Again, that's a live link through to that. And the worked example has actually got a lot of different examples. So if you are furloughing someone in September, where the contribution for the employer is higher and where somebody might have holiday, and some of the week is furloughed and some of the week is worked, what is the calculation? There are a number of worked examples to help you through, but it isn't straightforward. And helpfully now, in the new guidance that we got on Friday, there is a process where you can identify if you've made an error and you have overclaimed. They had previously advised that overclaimants could be corrected, and that the process is now included in the guidance. And they've also now added, which wasn't included before, an ability to highlight underclaims. Now, there is no process for underclaims other than contact the government in relation to that, and contact the claims people, but at least it's there. It wasn't there before, and it was highly worrying to people, for example, who hadn't included commission in the original claims, meaning they hadn't hit the 80%. They are, however, saying that they have got a monumental number of claims coming in, and that we shouldn't telephone the department. We should use the web chat in preference to anything else. So again, that to try and ease the pathway of any issues, follow the web chat if you can, because that would seem to be where the lines are going to be the most open. They are on the lookout for fraudulent claims. The definition of fraud seems to be wider under the guidance that came out on Friday night, and we know that they've already identified over 1,800 instances of fraudulent claims. And I have been talking to our fraud department today, actually, in relation to frauds that are likely to arise on the return to work and employees claiming against companies, which I think we can pick up a bit later. But we know a number of organisations run by well-known fraudsters have been set up to help employees claim in relation to things like, it wasn't safe for me to return to work, my employers put my health and safety at risk, my mental health at risk, my employers didn't provide the right PPE, my employers should have provided me with a vehicle so I could get somewhere safely, etc., etc. And that we are expecting a bit of a tidal wave around that. Obviously, the government are expecting a number of claims under this scheme as well, and I would say there will be a lot of audits. So the information we're giving you around keep your records and what you need to keep on your records is extremely important, because they will be on the lookout for that. So on that happy note, move on to the next slide about records. So records, as opposed to, so the agreement, as I said earlier, has to be kept for 5 years, but records of claims have to be kept for 6 years. So there is a difference, again confusing, but there's a difference between the two. And the records you should keep should include the amount claimed and the claim period for each employee, the claim reference number for the employer's records, the employer's calculations in case HMRC need more information about how you've worked out the claim, hopefully using their guidance, but obviously that's an important part. The usual hours worked, including any calculations that were required for employees who were flexibly furloughed, and the actual hours worked for employees who were flexibly furloughed. So there's being very specific about all the information you need to keep, as well as the fact that they need to keep it for 6 years, as well as the fact that you need the written agreement for 5 years. So record keeping has to be uppermost, as well as perhaps accounts and payroll in relation to these claims, and I'll let Simon talk about the issues with that. In terms of what you can do on furlough, that remains the same as before. If you move on the slide, please, Gina. You can, if you're on furlough, for the days you're on furlough, even if you're working, you can continue to undertake training whilst on furlough, but that has to be at national minimum wage pay, or it can be at furlough pay if it's more than national minimum wage. You can continue to volunteer, you can work for another employer, even if you are working days for your employer, unless that's specifically prevented by your furlough or flexible furlough agreement. And I've put in there, you can be a witness in an employment tribunal. We think you can certainly be a witness in a county court hearing, because there was a decision last week where somebody was to give evidence in court on a claim, and the judge ruled that them being on furlough did not prevent that. Now that doesn't bind HMRC, and it's different to actually the whole task of putting a witness statement together and being part of an investigation, but the job of actually giving witness evidence has been held so far to be not contrary to furlough. So just drawing that to your attention, because I know it's been a question that's come up. The guidance also clarifies again that you can be an employee rep and undergo collective and individual consultation whilst you're on furlough. So again, something that at the outset we weren't very clear about, but it is now very clear in the guidance you can do that. And as we get towards the end of the furlough scheme, I suspect there will be more businesses in the position where they do need to consult with people whilst they're on furlough, even if it is flexible. So moving on to the next slide, holiday. As before, there's not been a lot of change to the holiday section in relation to this, but holiday continues to accrue. It can be taken during furlough or flexible furlough, but obviously that will count as as a working day now, and it must be paid in full under the working time direction calculations. So the way that you calculate what's owed is in line with the working time regs. And you can require people to take their holiday if they can genuinely take it whilst they're on furlough. You can give them the notice again under the working time regs. We've had lots of questions around, what about people who go on holiday and when they come back, currently they have to quarantine for 14 days. What if they can't work? What can we do? Now, sorry, Jeannie can go to the next slide. Again, there's much debate about this, and it's worth going back to the sickness guidelines. Employees who have symptoms or who are isolating because they've been in contact with someone with COVID-19 are entitled to SSP. The job retention scheme is not really intended for those short-term periods of absence. Employees who are shielding, they can be furloughed, but they don't receive SSP if they are furloughed because they're getting furlough pay. But what about employees who are quarantined on their return from holiday? They don't fall into either category, well, certainly not shielding, but they don't fall into the category necessarily of people who have been in contact with other people who have the virus, because you don't know, they're simply traveling through an airport, or they've simply been in a country where they may have come across it. They could have done that here. They're probably not going to be considered sick. They're probably not entitled to sick pay. You're entitled to expect them to return to work. They've got an obligation to be available for work. But they may have booked these holidays before. So I think you need to be really clear now what your policy is. If you're going away, you need to be available for work when you come back. If you can't be available for work, then you're not complying with your requirements under your employment contract. And you either need to take unpaid leave or be able to work from home, or come to an arrangement with your employer in relation to this, maybe take extended holiday. But I think it's as well to raise these issues now before they arise, so you don't have disciplinary issues, a lack of consistency of treatment, arguments about fairness in relation to it, because it is clearly something that's going to come up, especially as a lot of people had already booked their holidays and they may not get their money back at the moment. So, you know, it is important that we look at that, and it may be that you use the flexible furlough scheme as part of a solution for that. As with everything, diversity and inclusion, very, very important in terms of the people you select for a return to work in relation to the people that are impacted by the ongoing issues of the virus. We know that certain groups are definitely more susceptible to the pandemic, and they may have more concerns about a return to work even on a flexible basis. So being aware of that and having a policy around that is particularly important. The school issue has not gone away, continues to get worse and worse in terms of both how uniformly it is not applied across the country, the rumours about how long it's going to extend, and the ability of people to work, particularly women, because when they're at home, they are generally taking the lion's share of the childcare and trying to work, and it's leading to other issues in terms of exhaustions and ability to be the best they can. So initially the flexible aspect of it was good, but it increasingly is causing a problem, and whether flexible furlough will assist with that is yet to be seen. I'm going to stop now and let Simon pick up, because I think I've probably had my 15 minutes of fame. Thank you for today.
Thank you, Kirsty. I'm just conscious of a couple of things. That we've got another half an hour to go, and we've got lots and lots of questions. And I know that Simon has been typing away, trying to answer,
Oh my goodness.
So what I suggest that we do, Simon, is that perhaps in your presentation you try and clarify a few points that have come up in the chat, and then maybe any points that you think need further consideration. But then if we try and answer all of the questions, we go through all of the questions and try and make sure that we provide answers to as many people as possible. Is that okay?
Yeah, it's good for me.
Yeah.
So if we go through these slides very quickly, some of them you'll see are very similar. Just going to put the caveat in on our disclaimer type of thing. This is we can't really give you specific advice without knowing your circumstances, but let's carry on, Gina, that's fine. As long as it's there. So I'm Simon Parsons, Director of Payments, Benefits and Compliance Strategies at SD Worx. I look after the government relationships. In fact, I received information I sit on the HMRC Employer Peril Group, and so we've reviewed the guidance. I don't necessarily know what the final guidance is until it's published, but I know what the draft guidance is and the draft direction. So I have some foresight, but it can, of course, change because I'm not privy to what's approved in the end. Let's carry on with the next slide. A lot of the information we've actually covered already with Kirsty, which is much appreciated. Next slide. Just some reminders. The scheme that we're in now closes. Next slide. Just thought I'd throw a picture of my grandchild, Rupert, and my eldest daughter. But those returning from parental leave can actually be furloughed. You can actually have them as a new starter into furlough up to the scheme closure in the end of October. So just a reminder, they're kind of the exception to the rule on the 21 days. But the principle will be is they're already not worked for 21 days. So I don't think it's have them come back to work and then furlough them. It's if you're returning to work, you can place them into furlough straight away, and so they're covered by that. Next slide. Repeat furlough, I think we're aware of. If you have repeated furlough, you still can repeat a further period of 21 days before the 30th of June, but they're not allowed to work for 21 days if you do that. Whereas if you restart it on the 1st of July, you have full flexibility available on what you do. Next slide. Yeah, so you can bring people back to do as much or as little work as you like from the 1st of July. So a number of the questions have been talking about days. There is no concept of days to the HMRC or the government in regards to claim. What they refer to is usual hours in the pay period you're making a claim for. And they'll give a number of bases. There's a basis for fixed people on fixed hours, people on variable hours and even piece rate or per item workers as well. So they provided a means of working out what usual hours is. Now, it's a common term use, usual hours, but it doesn't necessarily mean usual hours. Hopefully that is very confusing or makes some sense. This is the government's determination of what usual hours are. It bears no resemblance necessary to shift patterns, etc., unless they do form part. So the basis of calculation is what happened, as Kirsty said, in 1920 tax year up to the 19th of March, or the same period last year. So you may not have scheduled them to do any hours in June, but if they did 300 hours last June, 300 hours, or July, 300 hours is the usual hours. So it's not an intention of what it's going to be, but what it was. So just be careful on that. And equally, I think sometimes we get hung up about, well, they work Tuesday and Thursday, they don't work Friday and Saturday. Does that make any difference? The intention here is that with a claim, it gets down to a calendar period point, because furlough is from a point in the calendar independent of working days, because they're actually not working, and relating usual hours to that calendar period as if they didn't work. What are the usual hours? On comparing that with time they have worked. So it's a question of measuring time, and the requirement is still to pay 80% of the furlough pay coverage. So there is an element of proportioning that comes in, which I think I imagine I'm reading sort of Kirsty's mind here, but looking through the guidance is really complicated to work out. But it is there, and there is an online calculator, and I'm sure you'll see Excel spreadsheets modeling. If we go to the next slide.
There is a question from Angela.
Yeah,
You might
sure.
want to pick up now. Just clarifying the minimum furlough claim period of 7 calendar days.
Yes, there has been, or I'm expecting a further clarification. I haven't seen the terminology used officially yet, but there's a terminology of orphan days. And so the claim can be made for the orphan days at the beginning and the end of the month. I think this was pointed out to the government early last week, that weekly payrolls will struggle because they'll not realise until it's too late that a claim can't be for less than 7 days, because 1 week at the end of June includes a couple of days of July, and then that's not part of one claim. That will have to be 2 claims. So you'll have to claim the residual June days and the separate, say 1st and 2nd or 3rd July separately. And initially it was an element of, well, you can't have a 3-day claim, it has to be a minimum of 7. Well, they've relaxed that now, and for the start and the end of the month, the claim can be less than 7, but during the month it can't. So if you're starting after the 1st, your claim period, or ending it before the 31st, it has to be blocks of minimum 7 days or more. So there is take care. Plus there is sort of time limits that they're applying for claims now as well. So be careful on time limits. So for example, any furlough up to the 30th of June must be claimed by the 31st of July, or the grant application process for you is closed. So just be careful. Initially, it was probably hinted it would be open for a couple of years, but actually the chances, or the government have put a time block on it to say, all right, part 1, claimed by the 31st of July. Otherwise, you're too late. And you may find there are equivalents for part 2. In fact, we already know that if you don't claim under part 2 by the end of November, you're too late. I was hoping there may be an element of relaxation on that, because that makes it very tight for us to get all these calculations done, as they are really quite complicated. Does that help answer that question a little bit? But you can see the pattern of what's happening here is that in July, it's the same principle, apart from there's a proration of work time against usual hours. August, employers are starting to meet the whole of the employer's NIC and pension costs. September, 70% for furlough grants claim. The employer must top that up to meet the 80% minimum. And for September and October, it's a 20% percentage points subsidy, if we want to call it a subsidy, from the part of the employer, with only the government taking the 60% share of that 8% minimum furlough payment. So we can see that this is transitioning people back into work. Should we go to the next slide? So next slide after that, I think Kirsty's talked about rights. There are 4 or 5 steps to it that I talk about. These are mine. People will say this has to have an IT solution. So I've given an IT solution here. It's plan it. So you need to plan what you're going to do. How are you going to transition your workforce back? Agree it. That's the legal part that Kirsty's talked about the written agreements. You need to pay it, claim it, and keep it. So sorry if some people think I've cheated with the IT and not done an information technology part, but an element of this is intellectual planning, not an IT solution. And the other aspect that some people try is they try and think, well, it's all about payment, isn't it? Well, it is, to the extent of getting money in the hands of the employee, so they can go and spend it in the queues of the shops that are open today. But with regards to the other, they are completely different timelines. So your agree it is not agreeing payment, it's agreeing the whole process. Your pay it is dealing with your pay period that you're paying. The claim it is dealing with calendar months and different timings, and the keep it, again, is keeping all the records so that you have sufficient information to justify your claim, as HMRC have given quite strenuous powers to get back money from you if they believe you've done it wrong. Should we go to the next slide? So yeah, I think this is just saying part 1 closes 31st, part 2 closes 30th of November for the claim. So you must decide, and part of the claim process is deciding the length of the claim, not the payment. Claim is different to payment. They are separate, looking at different things. The first week that includes an element of July will probably have a bit of June, but your claim can only be July under the new scheme, and that goes for when you transition from July into August and August into September. The claim and the payment kind of separate, although they're related, they are separate activity, and we'll talk about different values. Should we go to the next slide? Okay, this is just talking about the orphans concept. Is actually, you don't actually have a minimum 7-day period for the beginning and end of the month. They can actually be separate, but just watch out for some very strict rulings on whether an individual that may have their furlough ended during that orphan period, what you need to do in the following claim period, because I think there may be obligations there. Next slide. Yeah. So usual hours, that's quite a task to do. Record worked hours and record furlough hours. They're the 3 pieces of information that are critical on any claim and working out payments, is knowing what are the usual hours, and they aren't what your contract says. They're based on a historic viewpoint, as is furlough pay. So the furlough pay element is based on what happened before the 19th of March or equivalents. Record hours worked, that's actual hours worked now. One will come off the other to work out the furlough hours versus worked hours, and then you'll have a proportioning calculation to be performed on the furlough pay in relation to work time. Pay them what's due under the contract, checking against national minimum wage requirements, etc. Next slide. I think we're probably at a point where we can go into questions. Why is it so complicated? Because these people like to make it complicated because they've got nothing better to do. Here we go to the next slide. I think we're probably towards the end there. There is a helpline. Kirsty's mentioned it. If you have any oddities, they are actually quite helpful. They will help with corrections. Once you get through, you may end up in a queue, but the web chat is seen as the best vehicle. You can try the phone number, but you may be hanging on for some time. But web chat, they will get there. Overpayments, there's an online method. Underpayments, if you need to claim more, you have to queue up at the headmaster's door, and the headmaster will have a chat with you about it. So that's the principle. So they will do it. but they want to talk to you about why. And so, but if you, of course, you've got genuine reason, they will sort it out. I don't think you'll get the cane or anything. I think that's outlawed these days. But they will want to verify why an underpayment had occurred. Next slide. I think we're probably at question point, or we can go straight to that. Oh, this is just a reminder. People get salary sacrifice wrong. It's really complex subject. Please remember that the furlough proportion part cannot be sacrificed. However, pay can be sacrificed, but be careful of national minimum wage breaches, because salary sacrifice is on a principle that they never earned the money. So it's not a deduction. So be careful with salary sacrifice. That's the only reason for repeating this. It's a common reason for furlough error, or some might say furlough fraud, because any error in relation to calculations, HMRC badges as fraud, which is an interesting concept. Next slide. Next slide. I think I've talked about all these. They're just the information in relation to salary sacrifice. Next slide. It's just to make you aware you're actually giving a free benefit. Next slide. Just keep on going through, Gina, and they're fine. So yeah. Yes, keep on going. And you can't go back in time. Fraud is an important area that's being concentrated. There's been over 2,000 claims of fraud by employees for it. Any questions we need to take to you, do you think, and handle? Hopefully I've covered some of those. With regards to holiday periods, I think I saw a holiday period question. You need to work out what the usual hours would have been for that holiday week. So it's nothing to do with the holiday itself, because there are no work time. But what they don't want you to do is average to a lower value by the holiday, but come up with a value of usual hours within that holiday period to be considered usual hours. I can't remember if I've missed any of the others that I saw. Hopefully I've answered some of them along the journey. TUPE was another one. TUPE does work for furlough, so you can. Sometimes you'll find that the claim process won't let you do it because it doesn't think you've had anyone on furlough, so it won't allow it. But the web chat and online helpline will process your claim for you. They will assist you and tell you what to do, potentially. But if you've got a TUPE situation or takeover, furlough can count. The fact that you weren't an employer on the 19th of March doesn't matter, as long as the employees were already in a pre-existing furlough arrangement from the former owner or former business prior to administration, etc., etc.
Okay, thank you, Simon.
Okay.
What I would like to do, I know that you have answered a few of the questions as we've gone along. Just want to make sure that we go back, because some we didn't take all attendees, so just want to go back and make sure that we have answered.
What she's trying to politely say is I failed to copy everybody by mistake.
I think Simon is as guilty as you are.
No, I did the same. I think I was answering Tia on every question. Yes,
he was answering me as opposed to answering the attendees. So we'll just go through. So there are 3 questions I can see in the Q&A. I don't think we've answered the first one. What if an employee cannot return to work because of childcare?
I'll leave that one to Kirsty, actually.
I think people are expected to be available for work in the normal way, but we are in a pandemic where people can't do that necessarily. You've got a furlough agreement with your employees. It's not for them to dictate when you use it. It is an agreement between you and them, and you give them notice to come back to work. If they can't come back to work, and you've got an opportunity to put them on furlough, they may seek to say it's a breach of trust and confidence to expect them to do that. But I think that's going to struggle in terms of a longer term argument. At the moment, what we're saying to employers is you need to be as flexible as possible. This is extremely difficult for people, and you want to retain your best workforce, and you want to retain talent, especially in the diversity sphere, and this is a genuine issue. However, you need to work towards getting people back in, and they need to try and find some solutions, but it's particularly difficult at the moment. So it's a choice really whether you want to keep them on furlough or whether you want to take a harder stance in relation to that, bearing in mind that there may be some arguments around breach of trust and confidence, or it's indirectly disproportionately affects me because I am looking after children to somebody else. But I think the top and bottom of it is they're supposed to be available for work. Generally though, at the moment, this is a massive issue for everybody. So tolerance and looking for solutions and encouraging people in terms that you should be seeking to find a solution so you can return to work is important, or looking at alternative flexible solutions. Not doing anything in relation to it isn't going to be helpful because it looks like the childcare issue is going to be a problem even after the summer.
Just a comment here, if I may. I mean, this is an experience of practical life, isn't it? But I know, for example, even in my son-in-law, my grandson has gone in on his webinar meeting or his conference call, and sometimes the comment from people is, "Well, can't your wife look after them?" And I think we've got to be careful because the mother works also. And that's probably important for your group, is actually we're now equal partners in childhood responsibility. We can't assume that a spouse has responsibility for looking after the children when both parents work.
Well said. In terms of the second question from Anna, I hear that so often that HR directors are saying, people don't want to work because they don't want to go on public transport. They don't want to get on a train. They don't want to get on a tube. I spoke to somebody on Friday who said that the majority of their employees were not turning up for work, and he had only been able to persuade this person, and I'll be able to persuade his PA to go in. Everybody, especially if you are in London, in big cities, people are saying we don't want to go into work. Kirsty, probably the answer is similar to the one in terms of I can't return because of childcare.
And I think there are sort of potential discrimination claims that are going to arise, because what's really clear is that certain characteristics make you more vulnerable. Your ethnicity, your age, your sex, all those three things. If you are an older man of an ethnic origin, and if you have a preconditioned health issue, then you are genuinely entitled to be more concerned, and requiring somebody like that to come back to work is putting their health and safety potentially at risk. And that, they're looking at the research that's being commenced at the moment. It's really only being commenced at the moment. That there does seem to be quite a legitimate complaint that actually some portions of society are more impacted, and there is a genuine concern about this. So we have to be supportive around that, because we want to maintain diversity at the moment. Really important that we have as much diversity as possible, because we've got to be as innovative as possible to be successful. And it isn't as fair for everybody in terms of a return to work. It's harder for some people. That said, there are a lot of safeguarding mechanisms in place, and there should be an encouragement for people, an enablement for people to return to work. So the systems in the office or the organisation or the location where you work, they're as safe as possible. That's one hurdle to be crossed. But then there is, how are you getting to work, and what ideas are you giving people, and how are you making sure they're safe when they are travelling to work as far as possible? What health support are you providing people with, and getting people comfortable with the idea of returning to work, I mean, we've got grab bags that we have now created for people who have to work outside of the office, say at police stations or on building sites if there's been a death, because they were going to, being told that there is PPE available at the police station. When you turn up, there isn't. So actually making sure you think about where are your employees going to be and how can you protect them when they get there? And how can you protect them whilst they're on the move? Do they need some of that whilst they're on the move? Can you help them with that? It is a cost, but it is a way in which you can help them overcome fear and help them with change, because that's the other thing is, this is all change, it's all different. And the first steps of getting back in and getting used to being on transport again are quite often the things that prevent people from coming in. Mm-hmm. You've also then got the people who are genuinely in a difficult position returning, and they're the ones that you look at maintaining them away from work. Again, selection is fraught with difficulty.
Okay, there were a couple of questions around collective and individual consultation. Is there a minimum number of individual meetings that we need to hold, or can we do the majority via collective consultation? And then something similar, I'm joining Angela's question regarding redundancy process and consultation, assuming staff are still on furlough.
So it depends on the circumstances. If you're in collective consultation, you'll need to consult with the elected reps in relation to the collective part of it, but that will not avoid the individual consultation. At the moment, if you are closing, the amount of time or the amount of meetings that you need on collective consultation is fairly limited, because there isn't a lot to say if you're closing certain sites. But you do need to have that collective aspect of it, and you have to be mindful of the timescales under the TULCA regulations, and then there will need to be thereafter individual consultation for people who are made redundant. It can all be done remotely. It can all be done using technology like this, and which it has I've already done it for a number of clients where we've used the technology to record the meetings, so the need for HR is reduced, and you can upload the recording, you can send it to people, and you can use technology to make information more available for everyone in terms of alternative roles, etc. But you still do need the usual employment rules apply in relation to consultation. You collectively consult until there's nothing else you can do in relation to narrowing the gap for avoiding redundancies. But if there's a closure, there's only so much you can say. So the number of meetings isn't that many.
And sorry, Simon.
Yeah, quick question for you, Kirsty, on redundancy.
You're not allowed to ask questions.
Oh, yeah. So shut up then. Some employers seem to be thinking they can furlough through redundancy notice. Any thought there?
Yeah, I think you can during the notice period, but you've got to pay the full notice entitlement that somebody has. There are more complex rules depending on whether you're entitled to more than statutory notice in your contract, which it might affect the top up. But generally, the rule is you can furlough them, you can claim the furlough, but you do have to pay the top up. So
you can't say redundancy pay is X, I only have to pay 80%. You'd have to pay 100%.
No, you have to pay 100%.
Yeah. But employees can remain on furlough during the notice period. Yeah. You don't have to bring employees back, which is one of the questions. I'm just going through the questions. I think there was one about performance reviews.
Yeah, I don't think you can do performance reviews. It's not clear, but I think that engages too much discussion about performance at work, which is for the company. You want them to improve, so you're helping the company effectively. It's a two-way thing, a performance review, rather than.
Well, I'm thinking from 1st of July, Kirsty, people could probably go through that sort of activity. Would that time be considered work time?
Yes, I think for the furlough days, you shouldn't be doing it on furlough days. You could do it on your flexible furlough days.
Have we answered Maria's question of a little while ago about could you in one day have someone furlough for X hours and working for Y hours? Could somebody work, be furloughed in the morning and work in the afternoon?
Yes,
Yes,
you
I think so,
can,
yeah.
but I think there's an element of understanding the concept that the non-working hours have got nothing to do with the day. So it's all about the pay period and the coverage of the claim. So within the claim that you're making, there's a date range. The HMRC and the government don't really take into account days not worked where you wouldn't have worked. They tend to flatten it so that every day in effect is a furlough day, even if it's a Saturday or Sunday. And so they're not looking at, did you work half a day? What they're saying is, what is the usual hours for the period? How many hours did you work? And the proportion is done on that basis. Hopefully that kind of helps, but it's divorce furlough from days of work because it doesn't really have a lot to do with it. It might help define the usual hours for a period, but it's how many hours versus how many not worked in a period. But in effect, yes, you can.
Okay. There are a couple of questions, one on pension.
Be nice, wouldn't it? When can I have mine?
Which, yes, yeah, that's the question. If I made redundant, can I have my pension early? I think it will depend on,
Depends on,
circumstances.
yeah, it depends on the pension scheme rules, but you potentially could, and what can be agreed and what's within the powers of the trustees. I tend to say because a lot of that is potentially in the choice of the employer, but I don't know how common is early retirement instead of redundancy these days, Kirsty?
I haven't seen much of it actually, but
Yeah.
would be nice, I have to say.
Things are different. You've got to think, going back some time, we were all members of defined benefit schemes. In effect, we still had full rights. These days, with defined contributions, you're as poor as the pot of money you have or as rich. So it's not so much a negotiating power that it used to be, because you may actually not have much money at all.
Right.
So, yes, I think I've met them all now, Kirsty.
Yeah. Oh, sorry.
It's not a problem. I think it's a nice reality of actually working at home and these sorts of things. And say culturally, we as an employer have come to expect it and accept it, because you could say with my daughter, the nursery, she's a key worker because she works in education. The nursery should be open, but it's not. So what do you do?
Well, mine are driving me round the twist. So.
Yeah, that's the reality of life, isn't it?
Yeah,
And
it
a positive one, to be honest.
Yes.
Because we're all families. Yeah.
I'm just conscious there is probably one question from Karen that we haven't answered. And there was a relation in many situations where we find ourselves bringing people into work on a new rate post-April 2020 national minimum wage. So is it right we'll need to calculate these hours on the new rates, but the furloughed hours will still be on the pre-April 2020 rate?
Correct. So the furlough is still based on earnings up to 19th of March. So that's your cutoff point. It hasn't changed and it's not risen, but your contract worked hours should be paid in accordance with your contractual agreement with the individual.
It's so complicated.
It is. Well, and that affects the proportion. The proportioning isn't based on what people are paid. It's based on proportion of time worked, and proportioning only really relates to the furlough grants. And I think that's why I'm trying to get earlier. It's not about the fact that they worked half a day. It's a question of how many hours are unworked in the period. And it's a flattened average, and it has nothing really to do with working at all. And most people won't recognize it. They'll say, well, it doesn't match their shift, it doesn't do this and that. It doesn't. That's a reality. But work time, pay under the contract.
I can see Claire's asked, do we need to state the proportion of hours to be worked in the agreement for variable paid workers? Employees, I don't think you'll be able to, because it's going to vary so much. So I think just saying it's going to vary and we'll tell you and you know,
Yes.
is the best you can do. Hopefully that helps.
Okay.
You may be able to calculate and notify them what the historic variable usual hours position is, but the agreement doesn't have to say what you're going to work, only that you're wanting to exercise, I think.
Before we wrap up, I always get in trouble with Lynn. Lynn, if you can, can let me know in the messages whether we have answered all questions, because I get told off in the end if I haven't answered all questions. So it's quite difficult to go up and down and scroll the chat and making sure that everything has been covered. But fabulous. I've got the thumbs up this time. Excellent. So, so one final question. Someone refuses to go to work because of childcare. Are they allowed furlough pay? I think
if you agree, yes, that's okay.
So I just bring it to a conclusion. Thank you so much again to Kirsty and Simon for joining us. Thank you to Gina for moderating everything behind the scenes, and thank you for all of you who have attended this webinar today. I know it's incredibly complicated. I find it very complicated, but you know, it's been very clear to you know, just having the explanation from our two experts, and we'll make the recording available to everybody just in case you want to go through the whole thing again, just to clarify a few points. And before I let you all go, I'll just mention we still have two sessions on our The Furloughed Leader series. It's been exceptionally well attended, and I said some phenomenal feedback. So you need to be a member of WHTL to attend the series. We've got one tomorrow and one next week, and I've already seen people asking for more and more sessions, which we will look and see. I'll mention the mentoring program. If you are in the mentoring program or are interested in the mentoring program, join us. I think it's on Wednesday this week, and we've got we're trying to bring back diversity and inclusion topics to the agenda. So we've got a webinar on the 1st of July on measuring inclusion. And I do let you go now, because I know everybody's really busy doing these calculations. Thank you so much, and I look forward to seeing you very soon. Bye-bye.
Thank you. Bye-bye.
Cheerio.